I would like to say thank you to Mr. Goodnight. He presented what we talked about, and I appreciate that. I didn't at the time understand what even diversion was. I've never dealt with any of this. But my life did take a change in 2010, and I didn't realize that I was affected as much as it has affected me.
All rise. Second Judicial District Court of the State of Nevada now in session. Honorable Barry Breslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. All right, welcome to Department 8. I'm Judge Breslow. We are on the record in cases number CR 19-1535A, that's Mr. Roger Hillygus case, and CR 19-1535B, that's Mr. Stewart Handte's case. The court recognizes and acknowledges the appearances of Ms. Berryman from the State of Nevada Division of Parole and Probation, Mr. Stege from the Washoe County District Attorney's Office, Mr. Goodnight from the Washoe County Public Defender's Office, and Mr. Ian Silverberg on behalf of the Washoe County Alternate Public Defender's Office. Also, of course, are Mr. Hilligus and Mr. Handte. This is the time and date set for sentencing. If you are wondering why the court advanced the date of sentencing up a week or two, reason was the court was supposed to be in trial yet last week and this week on a serious charge category A matter. It got moved, and so the court had this week available, and I didn't want to keep parties waiting any longer, so we moved it to today. In preparation for the sentencings today, the court has thoroughly reviewed the pre-sentence investigation reports that were prepared by the division and have been filed in the respective cases. The court has reviewed in Mr. Hilligus's case the mitigation brief along with the application for grant of diversion and the mental health evaluation contained therein. The court has also reviewed some emailed letters in mitigation, and as well as a list of people identified by Mr. Goodnight as advocating for or in support of Mr. Hilligus, who for strategic or other reasons, letters were not filed, but wants the court to know that these people support Mr. Hilligus going forward and ask for moderation or leniency in sentencing. The court also reviewed letters, victim impact statement that was filed in both cases from Mr. Hilligus's sister, Ms. Robin Renwick. Court is aware that in Mr. Handte's case, there have been recently some concerns by pretrial services that he was not in full compliance with his pretrial release conditions. The court exercised its discretion to refrain from calling people in to have a hearing on that in awareness that we would be here anyway for the sentencing today, and they were not of the type that were so concerning to the court that it was in any way concerned with public health, safety, or welfare. The court is aware of the negotiations that led to these respective nolo contendere pleas of guilt, and the court is aware that the state is not seeking, nor would the court have any inclination to sentence either of these defendants to prison, nor prolong, in Mr. Hilligus's case, his incarceration in the Washoe County Jail, nor send Mr. Handte to the Washoe County Jail. So, as the way things stand, pending argument from counsel and hearing from the defendants in allocution, the court is likely to end this hearing with a fair and just sentence that does allow Mr. Handte to have the GPS monitor removed immediately, and for Mr. Hilligus to be released either from custody, if the law allows that, from the Washoe County Jail, or alternatively, if he has holds that would require his transport to other jurisdictions there. The court is aware of the request for diversion and the reasons underlying that. We'll hear more about that, and the court will make a decision whether diversion will be allowed under facts and circumstances of this case. The court also is aware of filings yesterday by Mr. Handte on his own, not just discouraged, but generally not allowed when represented by counsel. One, substance of which had to do with an ADA advocate concern, namely that being denied or not offered one when he believes otherwise one should have been, and two, concerns about the continuing representation of him by Mr. Silverberg. Let me speak to that first because I want to make clear the court's view of that. The issue of Mr. Hante's representation, whether by outside counsel, counsel appointed at public expense, or by himself, has been covered by the court in several prior hearings. The court is not inclined to revisit them today. Combination of reasons. Primarily, they've been covered. Nothing's changed. Two, the closeness of the filing to today's sentencing hearing. And so it is of concern to the court that some would say it appears to be an effort to disrupt the proceedings from going forward. And three, Mr. Handte is aware that, and we have cautioned him before, he's not allowed to file things on his own when he's represented, even things that he wants having to do with his representation. So not only is the court not going to grant any of those two requests filed yesterday on an incorrect form, I would note, by Mr. Handte, but I'm not going to have a hearing. The court believes it has discretion under the circumstances to proceed. That's what the court intends to do. Mr. Hante's concerns are noted. Mr. Silverberg, if there's a position on that subject you'd like to put on the record, please do so.
Thank you, Your Honor. I have had a chance to speak to Mr. Handte today, and I think he's okay with me representing him in sentencing.
Well, I'm glad to hear that. All right. All right, so let's first turn then to Mr. Hilligus, and first from his attorney, then we'll hear from Mr. Hilligus, then from Mr. Silverberg, then from Mr. Handte, and then from the state. Well, first of all, I do note that there were concerns with the pre-sentence investigation report. So let's start there. Under Stockmeyer, they need to be brought to the court's attention prior to sentencing or at. You filed a brief that identified several issues, one of which was, Mr. Goodnight, that there is no legal requirement that certain personal identifying information of a defendant be included in the PSI, and you're asking, even though it's not available for public consumption, you're asking it to be stricken nevertheless. Is that still the ask?
Thank you, Your Honor. Let's start there. Joe Goodnight for Mr. Hilligus, for the record.
And the microphones are on green on everyone's desk. If not, please press them, and thank you.
In reviewing the pre-sentence investigation report, Mr. Hilligus took issue with the inclusion of his social security number, his state ID numbers, his driver's license number. And so in researching whether or not he could object to that, the authority I was able to find on what must be included in the pre-sentence investigation
Did not include that.
Did not include that. And so I made the objection on his behalf. He's asking the court to redact that portion. It would still include his date of birth, his name, his address, his FBI number, and so I think the prison will be able to tell who he is if he ever is sent to the prison.
Okay, I'm going to hear from the division in response to that, and the state if it has a position in a moment. Let's go to the other issue as well. I noted, like you did, that the PSI omitted the fact that the state was going to recommend probation for Mr. Hilligus. It was not specifically spelled out in the PSI under the section where the negotiations are identified. Would you have the court order that sentence be added and this be refiled, that page be refiled, or are we okay to proceed without an amended PSI?
So I think the court can amend it by interlineation on the court's copy, and that could go to the prison if he ever goes to prison.
And then and make sure that's filed.
I think it's cleaner. I think the statute allows for the division to take these corrections back and to file an amended copy or an improved copy that includes the negotiations as stated in the no contender rate plea memorandum. And so I think that's appropriate. The other issue that we took with the pre-sentence investigation report was
It's a very long statement of facts. I thought I saw
a very long
that.
statement of facts. He took issue with almost every paragraph there. I don't think making those objections and adding them into the record benefits his argument that he is asking me to make today. And so we are choosing strategically not to make those objections. However, one more point. Oh, the inclusion of a diagnosis from his mental health evaluation does appear to be required pursuant to the statute if he does make an election under 176.
Which he has.
Which he has. This is not the fault of the divisions. We didn't have the evaluation filed at the time they were penning the pre-sentence investigation report. It has been filed now. The division has access to it, and the court has access to it. The state has access to it. I think that final portion, the diagnosis and treatment recommendations, should be included pursuant to statute into his pre-sentence investigation.
Okay, hold there, please, then we'll get back to argument as to why the court should exercise its discretion and give Mr. Hilligus a chance at diversion, so never be adjudicated a felon versus probation, and an opportunity to move forward out of custody. Start with Ms. Berryman. The three issues you've just heard. One is the personal identifying information that is often included, but a strict rating of the statute does not appear at least to be required. Two being the fact that the negotiations here as set forth in the NOLO contender plea memorandum did specifically indicate the state would argue for probation, ask the court to impose a suspended sentence. And three, that there has not been an evaluation done, a mental health evaluation by the provider, and the conclusions reached. What do you make of all that, please?
Your Honor, we routinely on every pre-sentence investigation under defendant information on page 2, enter the social security number, the state ID, and the defendant's driver's license or identification card number if it's available.
So you know you have the right person?
So that we know that we have the right person. If the defendant either goes to prison or has a probation officer to make sure they have the right person. When someone comes into our office to meet with their probation officer, we often ask them for their driver's license or their identification card so that we can then match it up with the pre-sentence investigation report. Again, to make sure that we have the right person.
All right, so it sounds like it's custom and practice, but for what the state believes is a good reason. Hold on, Mr. Stege, we'll get to you in just a moment, please. And then as to the other two issues, please.
I don't have the guilty plea or the no contender plea in front of me. I'm happy to have an amended PSI filed and to make sure that it's clear.
It does say the state will recommend probation.
To make sure that that sentence is added. And as Mr. Goodnight said, we did not have access prior to the filing of this pre-sentence investigation of the mental health evaluation. That can also be added if Your Honor orders it.
Okay, thank you. I'm still thinking. Mr. Stege, what's the district attorney's position with respect to how the court should approach these concerns with the PSI?
The court should reject out of hand the constitutionalist motivation for not listing his social security number in the PSI. It is in today's
Objection, Your Honor, that's not my argument. And that's not one that Mr. Hilligus.
I'll let you respond.
Thank you.
It is the single most useful identifier across this country to use. So it should be included, despite his desire that it not be included in there. It's always helpful to come back to the law, and the law is that the court should not strike it unless it is based on highly suspect or impalpable evidence. It is not, therefore, it should be included. It is a theme of the defendant's, Mr. Hilligus' experience as a defendant to have his prosecution go in a certain way. It should go according to the law, which allows for this, and it's not highly suspect or impalpable. It's also noted that he wants to go to another state, and I envision it being difficult to the highest degree to go to another state and try to interstate contact without listing these very important identifiers.
Well, that's a practical reason, right?
Well,
That's not that's not discussing what the jurisprudence is or custom and practice that's been accepted and not a reason to vary from.
well, in which case the court would be doing it simply for his own individualized prosecution in this matter, which he's not entitled to, and the state finds that abhorrent.
What about the issue of correctly identifying the negotiations here? I'm assuming no opposition to that.
No, it should correctly state what is, I think best practice would be to put in what is listed in paragraph 7 of the agreement.
Word for word, right? Not,
Yes.
not paraphrase, but to identify it completely and specifically.
Yes, and similarly as to the mental health evaluation.
To identify the conclusions reached, the
Conclusion
evaluation
reached.
having occurred, who the evaluator was. We don't need 6 or 7 pages of background. We just need the gist of it.
The gist of it, I agree.
Okay, thank you. Mr. Goodnight, response to the comment particularly about the identifying information, please.
Your Honor, I took issue with the state's, I guess, characterization of my argument as a governmental issue. I'm basing it solely on the statute. It's not required by the statute. We'll submit it at that.
Okay, well, it's the court, it's the order of the court, and excuse me one second. Mr. Silverberg, I'm not ignoring the fact that you're here and might have a professional view of this, but since it doesn't involve your client, I'm not seeking your input, so I'm not trying to be disrespectful. It's the order of the court as follows. The PSI will be amended and a supplemental one filed by the Division of Parole and Probation to cover the mental health evaluation having occurred, the conclusions reached, and also to more accurately and completely identify the negotiations that were reached and memorialized in the nolo contendere plea agreement. The court denies the request to have the identifying information objected to by the defense removed, although the statute doesn't apparently specifically require it. I think there's a good reason for it to exist, and in the court's experience, custom and practice, in every case I've presided over, it's never not been there. Not that I can truthfully say I've checked every one, but I don't recall it ever not being there, I'll put it that way. So while there may be a legal argument to be made here, the court at this time does not find it persuasive and does not order it redacted to that effect. Mr. Goodnight, please proceed then with how you would have the court approach this sentencing hearing, why you believe diversion is viable, fair and just, and logistically could work, and anything else with respect to the terms of sentencing if the court does not opt for diversion.
Thank you, Your Honor. We did receive a victim impact statement from Ms. Renwick yesterday. In reading the statement, it contains 3 paragraphs. I would object to the second paragraph beginning with the words however. The court recalls that pursuant to NRS 176.015, victims of crimes, I do believe Ms. Renwick qualifies as a victim, being the relative of both Mr. Hilligus and her mother, who was listed as a victim in this case. They may reasonably express any views concerning the crime, the person responsible, the impact of the crime on the victim, and the need for restitution. I believe the center paragraph goes outside of those boundaries. It is based on hearsay, a conversation that she had with the Reno Police Department detective. It's, to use the state's word, highly suspect, and I don't think it falls under the proper heading of a victim impact statement. So I'd ask the court to disregard the center paragraph. I think paragraphs 1 and 3 are appropriate, aside from the second sentence in paragraph 3 that I think begins with perhaps, because it references the second paragraph. So. And if the court has questions about that, I can argue further, but that's my position.
Well, it's different when court receives letters as opposed to a witness testifying. If the witness started to testify in an area that generally did not concern impact of the crime on them, thoughts as to sentencing, or something closely related, the court could shut it down very quickly. When it's in writing, did I read that? I did. Does it impact the court's view of what a fair and just sentence is? It does not. If you're asking the court to say on the record that it will not use this in any way in aggravation, I do so now.
then I'm satisfied.
That would be error for the court to do that.
I don't think so, but tell me why you disagree.
Well, because a victim is entitled to give thoughts about the prospective sentence, and that it describes why she has thoughts about a particular sentence, meaning the future dangerousness of these defendants. To borrow the rules of evidence do not apply, so she can relate a hearsay statement.
She can.
Related to her fears of the defendant, and I should say defendants.
So Your Honor,
So it's not improper.
the fears that are cited by Ms. Renwick are in reference to frivolous or meritless lawsuits. The law affords for addressing that, the civil law, the court, if Mr. Hilligus filed a frivolous lawsuit, she could seek sanctions from the civil court, she could seek attorney's fees. That part of the civil world is covered under the law.
All right, let me stop you both. Let me stop you both, because I want to move this forward. The objection, the court will not consider the middle paragraph in aggravation. I won't. Does it possibly have some bearing as to Ms. Renwick's feelings, thought process, concern? Sure. Is it attenuated from the crime that these two fellows have pled no contest to? The court believes it's too far away. It's based on hearsay, which I'm allowed to consider in many circumstances. I exercise the court's discretion not to do so here. Now, do I direct a black line to cover through it? I'm probably not going to do that, but I will tell you, this will not be held in aggravation. It won't. I don't want to have any direct contact with my brother, or indirect, is somebody doing it on his behalf. Sure, that resonates with the court and will likely be ordered as part of whatever result there is here as to both defendants. But in terms of believing that this should impact the way the court determines a fair and just sentence, or whether diversion or not, no, I'm not going to use it for that.
Thank you, Your Honor.
You're welcome.
Your Honor, in regards to sentencing, Mr. Hilligus comes before the court asking for diversion. And it presents as a difficult proposition logistically. We discussed the prospect of applying for the local mental health court here in Nevada. I think he qualifies with the evaluation. He has a diagnosis. It recommends treatment. It recommends duration. And
You may not know this, I presided over mental health court here for 18 months, fairly recently, not this year or calendar year, but in the not distant future. I'm aware of the staffing process, I'm aware of the types of issues and cases and people that are accepted. I'm aware that it does a lot of good for a lot of people and has a good track record in helping people find their way.
I agree.
But that's not what you're asking for here.
No, it's not. Mr. Hilligus has asked me to argue for a customized diversion program, which I believe is allowable under the law. It's done in other courtrooms in this jurisdiction. Normally it's done with clients who are out of custody and who are in treatment in their local state where they reside. The difficulties presented to Mr. Hilligus is that he's here in Washington County and he's in jail. His plan, and it's a well thought out plan, he has friends who are willing to help him in the state of Tennessee, who are willing to provide him with housing, transportation, and who have gone to great lengths to find resources for him. Everything from a dentist to a mental health treatment facility. They found doctors, they found churches, they found physical therapists, all resources that he can access when he gets to Tennessee. That would enable him to participate in the mental health treatment that is recommended by Dr. Ferretti. And one issue that a lot of in-custody clients have is that they can't apply for Medicare or Medicaid while they're in custody if they're going to a different state. They have to be in that state to do so. And so that's a hurdle that Mr. Hilligus has to get over when he arrives at his destination. The other issue is that a lot of these treatment providers won't provide an acceptance letter without a court order from the court. And that's something, again, until he gets there and gets accepted, he won't have, and he can't deliver to the court in a day. And so for an out-of-custody client who can get some of these ducks in a row, you're able to make a better presentation. It doesn't mean that Mr. Hilligus is prohibited from making the same argument. It's just going to be a harder road for him to get there, and the court is going to have to set, I think, consistent and routine check-ins to make sure he's doing what the court orders him to do. One concern the court has, I'm sure, is that the Division of Parole and Probation won't supervise someone on diversion out of state. They have mechanisms in place to supervise our diversionary clients here in Nevada. It can be ordered by the court that parole and probation supervises people in mental health court, people in veterans court, people in adult drug court. And that's not available to the court in this instance. However, because Mr. Hilligus is, I guess, technically diverted or pre-adjudicated, I think he would still fall under the court's jurisdiction, and the court could assign him or order him to continue to check in with pretrial services, which is an entity that will supervise people out of state. We have defendants who are checking in with pretrial services over Zoom, defendants who are sending in progress reports to pretrial services, proof of Alcoholics Anonymous or NA. These are just examples, not necessarily what Mr. Hilligus needs, but they're sending those in, and pretrial services can report back to the court. And about the time Mr. Hilligus misses a check-in or misses a Zoom meeting or doesn't send in a progress report from his treatment provider, pretrial services notifies the court sets a hearing, and we talk to Mr. Hilligus. The court was on the bench through the entirety of the pandemic and saw how we were able to hold court over Zoom and how, despite the many challenges, it worked fairly well. People, even today in the adult drug court, the participants in Washington County's adult drug court appear over Zoom. They're not coming into court. They're appearing over Zoom. So this can be done. The court can do it. It is a special ask for Mr. Hilligus. He understands that. The reasons why he feels it appropriate are, to start, his lack of any criminal history. Mr. Hilligus is 57 years old. Until 2019, he'd never been arrested before. There was a mention in the PSI of a contempt order out of the guardianship case, but it comes with no disposition. I think it had to do a lot with the battle over the guardianship that was in regards to his mother and father. But prior to that, there was nothing. And I think that demonstrates a very law-abiding and admirable lifestyle. You saw in both the sentencing memorandum, the pre-sentence investigation report, the psychosocial report authored by Rebecca McKibben of our office, that he had a fairly normal childhood. He had loving parents. His father was strict. His mother didn't show a lot of affection, but they were there for him. They supported him in his sports. They supported him in his schooling. They supported him in his travel. He went abroad. He has taught English abroad. And he has worked through the majority of his lifetime, whether it was household chores, ranch chores, tending to their property, or
Driving a school bus.
driving a school bus.
Right, saw that.
And the court knows, and Mr. Hilligus will tell you, I was a student on Mr. Hilligus' school bus in the 80s. And so I don't think that affects our relationship at all as attorney and client, but it goes to show, and I don't want to make myself a witness in this case, that he was a member of this community, and he was an outstanding member of this community. He worked for the Forest Service for, I want to say 8 years, 15 to 8 years, doing everything from firefighting to logistics. He did a lot of good to help this community stay safe when forest fires rage across the land, and to save homes, save livestock, save people. I think that should be recognized by the court. It was in 2010 when he suffered his head injury and the traumatic brain injury that really was the pivot point in his life. And it's at that point where you can see from the evaluations where his personality changed. He was experiencing depression and the fact that he couldn't do a lot of the active things that he liked to do. And when the court zooms out and looks at that period of his life from, say, 2010 to 2019, 2020. And
Different guy.
totally different guy. And you can kind of see this change in Mr. Hilligus, not necessarily for the better. And you can read in the reports where he starts to become more irritable, more angry without rationale why he's becoming angry. And you see how those are symptoms, those are sequelae of what happens post-traumatic brain injury that manifest themselves in some of these irrationalities, in the paranoia, and in the depression that really starts to take control of his life. And you see him start to go down some of the rabbit holes online with some of these anti-government establishments. You view his life in the context of someone who is fighting for the guardianship of his parents, two people he loves dearly, but who is also experiencing these post-traumatic brain injury symptoms and consequences. You can see where his perception is where to go wrong, where it's subject to influence. And a lot of the supporters that Roger has are people who are advocates when it comes to the guardianship processes and the guardianship laws across this country. And unfortunately, guardianship is something that can be abused by evildoers. It's something that can be taken advantage of, and people go to prison for abusing the guardianship process. And you can see how Mr. Hilligus, through his paranoia that was driven by the traumatic brain injury, took this position that he was being victimized as well, and that his parents were being victimized as well. Whether or not they were is not a matter for this court to determine. But it gives the court context when looking at Mr. Hilligus in what was happening with him with the 2010 brain injury and then the 2019 accident where he fell off the roof, hit his head again, and spent a week in the hospital. Things really started to go downhill for him there. He loses his wife, someone who was by his side through that injury and before, someone who he had had a very fulfilling and loving and supporting marriage with. He lost. And he goes from someone who, prior to the accident, is employed, he's married, he's living a fulfilling life, to now he's destitute, he's divorced, he's lost the friends he had prior to the accident, and he's in this bitter case in his mind that he's trying to reconcile with what he really thought was right at the time and the actions he took. And so the evaluations show that that treatment will be beneficial to him. He wants to know why he has this paranoia. He wants to know why he gets so angry so quickly, why he kind of goes up and down. You won't hear much from Roger for a while, and then you'll get a flurry of emails, and I think that is symptomatic of his mental illness. And so I'm sure the state's going to talk a lot about the damage done in this crime, the potential trauma it caused to his mother, the worry that it caused to his sister, the resources that were used by law enforcement in multiple states to try and bring Mr. Hilligus into custody and back before the court, and then all of the numerous legal filings and legal arguments and issues that Mr. Hilligus has presented before the court as argument to why this case should not be diversion. And I think the court really needs to look at that through the lens of his mental health diagnosis and what's going on with him now versus who he was prior to 2010 and how he was in that person. And so when you look at it through that lens, I do believe that diversion is appropriate. and that the court can tailor a diversionary program that gives Mr. Hilligus the treatment he wants and needs, provides supervision for the court and the state so they know he's not committing any new crimes, he's not using any controlled substance, an issue that has never been an issue for Mr. Hilligus. He doesn't drink or use drugs. And he's doing the treatment he needs to do. And he has no contact with Ms. Renwick. He has no objection to that. That's a sad part of his life that they're estranged, but he doesn't have a problem not contacting her. He does have two cases one case in Story County and one case in Lyon County. One's a traffic citation and one's a misdemeanor. Those should resolve fairly quickly. And so my suggestion is for the court to order him to diversion, release him from the jail so he can go take care of those holds, and then have him come back in a month and we can see where he is in the country, whether he's in Douglas County or Lyon County, and whether or not he's made it to
I think you meant Story County or Lyon, right?
Thank you, I did misspeak. Whether he's made it to Tennessee, whether he's in treatment yet, and whether he's abiding by the court order. If he's not, then the court simply issues a bench warrant and he gets arrested and he has lost the opportunity that he so strenuously begged the court for. And he has everything to lose by not complying with the court. The felony conviction for him is very important for him to avoid. He spent in custody for 550 days now. The range that the court could present, I guess the worst case scenario would be 4 to 10 years. I don't think that's appropriate for Mr. Hilligus given his mitigation, given the lack of any criminal history.
Let me ask you to pause just for a moment and just observe something. You know, I went back and looked, and it was an imperfect look, I admit, but there were at least 4 different occasions on our journey of this case where I uttered the phrase, "I want Mr. Hilligus out of jail." And when I said that, I truly meant it. Didn't want him lingering there. Was looking for a path forward for him to avoid further incarceration. Indeed, when the court took the pleas here, the nolo contendere pleas, the negotiations were, and the court was fully intending to follow them, that Mr. Hilligus would be released from custody, as I recall, that day. Now, unfortunately, he didn't really have a place to go, and because for that and other reasons, it was determined that he would await sentencing or diversion. Didn't know there was a diversion asked, although I was aware the negotiations allowed for it to be sought, if appropriate, pending this hearing. But 550 days, I acknowledge, is a long period of time to be in the Washoe County Jail. But I just want to make sure everyone recalls the court took absolutely no satisfaction in those days that he spent there. I was all for approaches to get Mr. Hilligus out and do something productive in compliance with, you know, pretrial services and his obligations for matters before the court. But it was never the court's intention, I'm quite sure the state's intention, to ever have him spend more time in the Washoe County Jail than needed to be spent.
And that wasn't the focus of my comment here.
Okay, I just want to make sure that everyone understands that.
Yeah, and he does have these holds out of the other jurisdictions. We took steps to try and resolve those holds. Unfortunately, we weren't able to. And so logistically, he needs to be released from Washoe County so he can
go there.
address those holds. Again, obstacles that can't be overcome by Mr. Hilligus and by this court. So I will end with this. If the court's not inclined to grant him a diversion request, that he would ask the court to follow the negotiations and sentence him to probation with an underlying sentence of 12 to 30 months based on his lack of criminal history and the amount of time he spent in custody thus far. However, his almost sole request is that you grant him a chance at diversion so he can get this felony off his record after performing and doing everything the court orders him to do.
Thank you. Well stated. I understand your position, Mr. Hilligus. You can address the court seated, but please have the microphone put in front of you. Speak up, and the law allows you an opportunity to make a statement in allocution Anything you'd like the court to consider before we move forward?
I would like to say thank you to Mr. Goodnight. He presented what we talked about, and I appreciate that. I didn't at the time understand what even diversion was. I've never dealt with any of this. But my life did take a change in 2010, and I didn't realize that I was affected as much as it has affected me. I do want an opportunity. I do have a large support system in Tennessee. They've made a lot of strides in making it workable for me to get the help that I need, and I've complied with investigations through psychologists and social workers, and I'm at a point in my life that I'm very hopeful to get to Tennessee to get the help that I need. I've asked for help. I'm eligible and I qualify, and I know it's a big ask, but I'm up to the challenge, and I don't believe that there's much of a challenge. I will comply with what I have to do to make this work. I just want to be able to move on with my life, and being kept here in Washoe County is not helpful with my mental health. And I'm eager to get to Tennessee, where I've got people that care about me and want to help and support me.
Thank you. Mr. Stege, what's the state's position on a fair and just approach to the sentencing hearing as respect to Mr. Hilligus?
Diversion's not wholly inappropriate in this case. I'll borrow a word that the court just used, attenuated. And I think it's useful that the media is here to see how attenuated this ask is. Depression is the diagnosis. Now, depression does not make you engage in a years-long campaign to undermine the authority of the family court. Depression or traumatic brain injury. Now, I will say, we have from the psychologist a diagnosis of depression. We have from an in-house social worker just making a loose connection between, yes, when you have traumatic brain injuries, you can have mental health effects. But that a diagnosis does not appear from the public defender in-house social worker. Nonetheless, that does not, there are many people, unfortunately, who have traumatic brain injuries. Many people also suffer from depression. The depression seems to stem from his own actions, right? The court cannot forget that through the good work of the lawyers and the incredibly patient work of the family court, an appropriate guardianship was set up that the defendant at every turn undermined. Depression does not cause you to do that. Major or episodic depression does not make you engage in that campaign. For example, a SWAT team, as I outlined in my other acts motion, a SWAT team had to go out to remove Mr. Hilligus from the house that the court had ordered him out of in order to care for his mother. Depression does not make you engage in this campaign where which is based on greed, right? This is a greed-motivated crime. It is spelled out in this case that the house was meant to be sold. The final day was the day after Mr. Hilligus went and abducted his mother from the nursing home. He also sent those other documents indicative of greed to PERS saying, hey, all this stuff that the court did, we undo, and where should the PERS payments go but Roger Hillygus? Depression doesn't make you do that. Traumatic brain injury doesn't make you do that. This crime is premeditated over years. For example, we have in a YouTube video months before this offense, Mr. Hilligus saying, this good work of this court's sister judge and lawyers in this community setting up this guardianship and giving the defendant so much due process, but him saying in this video, saying the only way around it is to flee the state or flee the country. That is premeditation, not depression. It is argued that the question of abuse of Mrs. Hilligus is not before the court. Well, the question of abuse of Mrs. Hilligus is factually non-existent. To wit, the defendant himself, Roger Hillygus, made a complaint to Aging and Disability Services claiming that his mother was being abused. That was thoroughly investigated and found to be baseless. That was motivated, another greed motivation. Depression doesn't make you greedy, personality traits make you greedy. His greed, he wanted to stay in the house and keep the house because he thought it was his. It should go to him, he thought. Rather than, as the court determined, Mrs. Hilligus's care required the sale of the house. To wit also, leading up until this kidnapping, the defendant had not visited his mother in a year. Depression doesn't make you do that. Traumatic brain injury doesn't make him do that. In the meantime, he was out there premeditating getting this bogus legal document, linking up with these, Mr. Goodnight, my colleague, calls them advocates. I mean, they're the same people whose media we have put in exhibits, who call these places like Mr. Handte does, Auschwitz's, people who claim to be advocates but are really not able to point to abuse, right? It's these advocates think that the volume of their voice, the volume of their claims is more important than the substance of them. And the substance in this case was that Robin Wenwick, her lawyer, all the lawyers, the courts were doing what was best for Mrs. Hilligus, hiring experts to help them decide what the best care was. So, now, absent here is, of course, locally, if you want to get into mental health court, you staff it to see if they will take it, if they will accept an individual defendant. The absence of that in the pleadings tells me that they won't take him, or
Objection. It makes assumptions that aren't correct.
Well, there's not been an argument that there's been an ask that was refused, or when wasn't sought, or something they've just determined would be a good course of action more recently, but the court notes there is no acceptance letter.
There's no acceptance, which I think the court can infer either that it either was staffed and was rejected. I think we would know that, or it was deliberately not staffed because of the deep understanding of the qualifications and that Mr. Hilligus would likely be rejected.
I'm not going to accept that. I'm going to. In the court's mind there is no acceptance letter. I know the evaluations occurred more recently, but it's the usual approach that somebody asks for this with an acceptance letter. I've had people ask, subject to acceptance. I postponed hearings, but I'll decide how we should go after I consider everyone's argument.
And Your Honor, can we heard on that?
You may.
So the assumptions that the state makes are assumptions alone. There was no
They're
acceptance
inaccurate, is
letter.
what you're saying?
There was no rejection letter. And so I can tell the court we did not apply to mental health court, not for any reason that the state is making, but for our own reasons.
Or they determined to not seek it here because of the approach that they're seeking for the court to allow it to proceed outside of Second Judicial District Court Mental Health Court program.
And so that, I think that's valuable for the court's consideration that Mr. Hilligus wants diversion for mental health, right, a supposed mental health issue, but deliberately did not staff it with the professional entire team that this court employs to make those determinations and to appropriately align the proper defendants, which again, he is not one, with the resources available. So diversion is, in the state's view, Mr. Goodnight himself said it's a big ask, right? It is a bridge too far. I would key in on the claim that now he has everything to lose. He had everything to lose when he fled, right, when he fled. And the reason he's in custody is because he fled when the court ordered him to appear for competency evaluations, and instead he fled the state for a number of months.
Well,
Did
pause, please, to comment on that, and just remind everybody, the court did, I wouldn't use the term move some mountains, but ask people to move expeditiously to arrange 2 professionals to come to the courthouse, I believe a week apart, to meet with out-of-custody Mr. Hilligus, at a time when it was difficult to find professionals available. We had it lined up for him to hear, and he didn't appear. So
yeah,
that doesn't work to his advantage, obviously.
yeah, to his incredible disadvantage, and he was located in Missouri, right? And, you know, another important aspect of that particular event is that Mr. Goodnight notes that, you know, people in drug court appear over Zoom. The defendant was appearing by Zoom from the Hoff Memorial, if the court recalls, and ordered to appear for his competency evaluations, right, and he fled. So underscoring the ineffectiveness of Zoom as a supervision model, right? It is pointed out, acknowledged that if he's on diversion out of state, there will be essentially no supervision, right? The division will not supervise him. So instead of diversion, the appropriate, and let us not, you know, a theme of this sentencing or the state's position on this is that this defendant has sought at every turn to undermine the authority and the legitimacy of this court. That he has tried to legitimize tactics that are not legitimate. I refer, of course, to the constant onslaught of sort of chain emails, these claims of abuse of the defendant in jail, these claims of murder of the victim, these claims of corruption by any judicial officer that has been involved in the case, these sort of completely baseless claims of corruption and law and things of that nature. That is harmful. It's harmful because this court relies on, this court and other judges when they say, this is the court's order, this is the court's decision, right? In many of those decisions, the parties do not agree with or wish it went a different way. But the court relies on as a foundation of our society, people follow those orders. And at every turn, Mr. Hilligus has sought to delegitimize and undermine those. And for that reason, diversion is not appropriate. The appropriate sentence is a 4 to 10 underlying sentence. The probation should be for 3 years in accord with the agreement as it relates to Mr. Handte for a 3-year probation term. That underscores or supports this court's authority, promotes respect for the law, adequately addresses the harm done by this crime. Let's not forget what this crime was. A doctor had determined, and a court, after appropriate litigation, had approved that Mrs. Hilligus, because of her health situation, ought to live at this memory care facility, where she was cared for 24 hours a day, and you know, her condition was quite advanced. And Mr. Hilligus, you know, without any authority of law, in fact, deliberately designed to be unlawful, took her from that environment. When she was admitted to hospital in Southern California, she was not in a good condition, of course, because he had not taken her medication, was not skilled in the ways of caring for her, and so that causes harm across the board. And for that reason, I asked for 4 to 10 underlying. Of course, the extradition costs ought to be ordered. No contact should be ordered as well with Mrs. Renwick and her family. I also, given sort of the conditions that have had to be imposed on Mr. Handte, I asked for light conditions there. That as a condition of probation, do not have contact with any of the parties, witnesses, etc.
Thank you. All right, the court will pronounce its decision with respect to Mr. Hilligus shortly. Let's turn to Mr. Handte. Mr. Silverberg, are there any changes, corrections, modifications to the pre-sentence investigation report you'd like to bring to the court's attention? If so,
Thank you, Your Honor.
tell us.
As to the pre-sentence investigation report, I think the concerns I'm sure that both Mr. Handte and Mr. Hilligus have is that they fundamentally disagree with the narrative, but they are from the police report, so I think it goes more to argument as opposed to something that needs to be stricken. Then I want to start with, I think what led to Mr. Handte sort of getting in deep water in this case, which was the perception, and I say perception because it was admitted by law enforcement at the preliminary hearing that this was false, that he employed some sort of a ruse to get into the care facility where Mr. Hilligus was. That was Detective Jenkins on the stand at the preliminary hearing, who admitted on cross-examination that she was wrong, that the signing sheet had Stu and Gus on it. Stu Handte, Gus Roger Hillygus. Nobody was trying to trick anybody.
Gus being nicknamed Hilligus, Gus nickname for...
Yes.
Okay, got it.
And that was admitted to, and I think that's important when we try to look at Mr. Hante's motivation in this case, because the court should know that Mr. Handte had nothing to do with the guardianship or the underlying, and yet he came in quite after the fact to help somebody, Mr. Hilligus, who he felt had a righteous claim. Now, I want to tell you a little something about Mr. Handte. Many years. First of all, he's a zero criminal history, lifetime public servant, law enforcement. There was a time that he worked at the Nevada Highway Patrol, and there was a...
He was a witness in court on criminal justice proceedings, if I recall right.
So,
I think that one or more of my colleagues might have been, my judicial colleagues were prosecutors at times when he was a witness, and he might have had personal experience testifying and meeting with them and truthfully testifying as to what was going on.
an exemplary and a distinguished career. And I don't say that lightly. When he was at the Highway Patrol, there was a trooper, and a female trooper. And, Your Honor, at that time, it may still be going on, but at the time, in law enforcement, and certainly at the Nevada Highway Patrol, there were some issues there with treating women fairly. They would often run into issues for promotion, and God forbid if they ever speak up about it. And so there was this one person who had complained about the treatment she was receiving. And she could not find one person. Even though everybody knew it, she couldn't find one person that would come forward and speak on her behalf. She did find one person. And that person was Stu Handte, who at great peril to himself spoke up against the chain of command about the treatment that his coworker was receiving. I know that story because I represented her back when I was in private practice. And Mr. Handte was the only one that would come to my office and support what she was saying. And when I say at great detriment to himself, it's not an understatement, Your Honor. When you speak up against the chain of command and the Highway Patrol or some other areas of law enforcement, you're going to suffer retaliation and you're not going to be there very long. But that didn't matter to Mr. Handte because it was the right thing to do. And he believes in this case that what he did was the right thing to do, which is why I started with this issue about the preliminary hearing and the state's allegation that there was some deception in entering the nursing care facility. There wasn't. I'm sure the state will mention, and maybe you could all wonder how Mr. Handte has conducted himself throughout this case, where some might consider his actions or statements to be provocative. And I just want Your Honor to have the context, because I think this case has been an eye-opener to Mr. Handte as well. He's, as I stated, an exemplary career in law enforcement, where he's been a witness for states and cities, and no one's ever had a problem with him telling the truth. And I think that when he saw that the treatment that he was getting and being sort of painted into this criminal, I think he was absolutely incredulous of that. He couldn't believe that this system that he had worked for his entire life, where he doesn't even have a traffic ticket, is now kind of being turned against him, his words being twisted, his motivations being questioned. And I think that sort of tells the court a little bit about why Mr. Handte has reacted the way he has. But he sits here respectfully before the court. And but I thought it was important for the court to have that background. I can tell Your Honor that in a lifetime of, as a career defense lawyer, well, I've never seen this burglary charge come up in this context. It's usually far different, as Your Honor knows. Drug addicts breaking into residences, causing trouble, or things of that nature. I venture to say that none of us has ever seen a burglary charge arise out of the facts of this case. And it reminds me a little bit of law school, where you get a bar exam, you get a fact scenario, and the examiners want you to find every possible civil and criminal issue that could be raised in that fact scenario. But as a more seasoned attorney, you learn just because you can check the boxes doesn't mean it's the right thing to do. Doesn't mean that because you can prove burglary that it should be pursued. And I don't think this case should be pursued in the criminal context. But it's sort of developed its own momentum with people's reactions to being accused of crimes that have absolutely no criminal history at all. So what then is a just sentence in this case, Your Honor, for somebody with absolutely no criminal history? Given the context of this case, when Mr. Handte became involved in it, far after anything happened with guardianship, far after, anybody that would appear before this court could expect a minimum sentence. And that's what I'm asking for here, Your Honor. I'm asking for a 1 to 3, a 12 to 36, suspended pursuant to negotiations. I don't think that, and I know sometimes the court will impose additional jail time as a condition of probation. I'm going to ask the court to not do that in this case. Mr. Hante's already served off and on 103 days. So I don't think that any additional jail time would serve a purpose here. He's got to keep his nose clean for the next 3 years to get the benefit in this case, which is withdraw his plea to the felony, enter a no contest plea to a gross misdemeanor with credit time served. I have no doubt that he will succeed in that. And that's what I'd ask the court to do.
Thank you.
Thank you.
Mr. Handte, the law allows you to make a statement to the court with respect to sentencing. Tell me anything you'd like the court to consider.
Thank you. Thank the court for allowing me that privilege to address some issues that need to be addressed. First of all, facts. Facts versus fiction. The day of this incident that took place was a day that is emblazed in my memory probably for the rest of my life. I would say the rest of my life. Prior to that day, I contacted the Reno Police Department to facilitate a meeting between Chief Soto of the Reno Police Department and Mr. Hilligus. I did not get a response back from Chief Soto. What I got a response back was Commander Miller, and he asked me, what did he want the Reno Police Department to do? I said, Ollie, because I knew him personally, just sit down with the man. He's got some papers, present it to him, or he's going to present to you, and it's up to you guys from this point. I'm not involved. I wasn't in law enforcement. It's in their wheelhouse. That's exactly what I said, Judge. Exactly. My father had a photographic memory. I don't have a photographic memory, but I've got a pretty good memory for a 63-year-old guy. And that's what I said to Commander Miller. Commander Miller did not meet with Mr. Hilligus and the third party, Tracy Griffith, who's never been charged in this case, which is of note. A Sergeant Hannafin did, all recorded on body cam footage, and specifically states, well, Mr. Hilligus, when you go up to the facility, tell him to go up to the facility and see what you can do to have your mother taken out of there. That's what took place, not what was said throughout the media, not what was said by the district attorney's office, but that's what took place. So all three of us were there. As Mr. Silverberg says, I signed in appropriately, but that's not what was said in the media, the local media. Actually, the media across.
Mr. Silverberg, slide the microphone a little closer to Mr.
Certainly.
Thank you.
Actually, the media across the country, my father-in-law at the time saw this news story in North Carolina. A friend of mine who was vacationing in New York City saw this news story on the news in New York City of a character assassination of both Roger and myself over lies. So we signed in, as stated, and we left that facility with Mrs. Hilligus, arm in arm with her son, smiling from ear to ear. Nobody stopped us, there were no concerns. We casually walked down the road, dragging her across the parking lot, which was told into the media. I took Tracy Griffith back to his vehicle and dropped him off. Then at 11 o'clock that evening, on the 8th of August, 2019, all hell broke loose. I got a call from Commander Miller accusing me of kidnapping, accusing Roger of kidnapping. And my response back to him was, wait a minute, you people met with Mr. Hilligus. If you had any concerns, why weren't they addressed now? Which was totally not addressed then. They said, go up to the facility. Then a silver alert was issued based on lies. Lies. Not armed and dangerous. Maybe he had access to guns because he's a hunter. Not threatening people with guns. There's no threats involved. The Los Angeles County Sheriff's Office SWAT team greenlighted him, Judge. Had he gone over to that window, he would have been headshot over lies. Lies by the district attorney's office. Lies by the media to paint both Roger and myself as these hardened criminals who drugged his 80-plus-year-old mother across the parking lot to kidnap her. For what purpose? I've been labeled a threat to the health and safety of the Reno Sparks community, a place I've lived for most of my life, 49 years plus, 30 of which were in the law enforcement profession. That is in a document that the district attorney's office has provided to this court, without any factual basis or foundation to set forth that statement. Another example of character assassination. I've never threatened people, although that's put in there too. Handte has previously made threats to kill. Based on that. No reports, no nothing. I believe Mr. Stege in the district attorney's office garnered that information from an incident that took place back in 2001 when I was relieved of duty as a state trooper. Which, if you didn't think that hit me in the bell, it sure as heck did. Because I had become a federal whistleblower against my own department, and that's why they relieved me of duty. Also, another statement into the court docket, into the court record, that I've been fired from every law enforcement job in the state, including Nevada Highway Patrol. That was a lie. I have a retired ID card that they don't give to people fired. I've gone to other law enforcement agencies, been serving as a sheriff for the county, 2 tribal chiefs of police, 2 stints as a deputy sheriff, and an adult probation officer. If people were cognizant of the fact that if you're fired from any law enforcement job in the state of Nevada, you will not get another law enforcement job in this state. I mean, that's according to the Nevada Post, which governs all law enforcement agencies in the state. More lies, misrepresentation of information, misrepresentation of facts. There is a Zoom hearing, as Mr. Stege alluded to earlier, on the 13th of January 2022, where yourself, Your Honor, stated that the GPS tracking device monitor does not apply. But then again, it did. There was a United States Supreme Court case, Torrey versus North Carolina. Brady Torrey was a convicted sex offender, made aware a GPS tracking device. That case was already taken all the way through the North Carolina courts. to the United States Supreme Court where they overturned the decision and said it was an illegal search and seizure of a person's body, violation of the Fourth Amendment. As speaking to amendments in my body, violation of my civil rights, First Amendment, Second Amendment, Fourth Amendment, Fifth Amendment, Eighth Amendment, and 14th Amendment. All that I've documented and researched for the last 4.5 years of my career, that is systematically been set upon us by malicious persecution and prosecution by the District Attorney's Office, fueled by falsehoods contained in police reports, by the lead detective who perjured herself on the stand after being caught by Mr. Silverberg, stated by my second attorney, Mr. Pitaro, being caught by saying I'm wrong and mistaken. And then when presented with the fact, well, here's the sign-in sheet, and she stated, Judge, it's the first time I've seen the sign-in sheet, however, there's video evidence to prove otherwise. In fact, the day I was arrested, at gunpoint, on the 14th of August, 2019, at gunpoint, fingers in the trigger guard, 6 guys in a tactical operation units, taking me down with excessive use of force. For what purpose? I didn't threaten anybody. I'm not a threat to anybody. Mr. Hilligus is not a threat. We've lived in this state, he and his whole life, me for most of my life, but I was treated like a hardened criminal. They hurt my back. Still not 100% to this day. The arrest outside of Elko, I had no intention of leaving the state, Judge. I was going there to talk to a gentleman who's friends with Roger about the GPS tracking device. I had no travel restrictions, but I was told, not by the court, not by my attorney, not by anybody, except by a news reporter, that a $100,000 cash warrant for my arrest. How did he get that information? He called me on my cell phone, Ed Pierce from Shelley. On the day I was told that a $100,000 warrant issued by this court. Do you think that's correct, Judge? A news reporter telling me I have a warrant for my arrest? After my first arrest, I will state facts here. And these facts can be confirmed if you choose to listen to what I have to say or even talk to the people that saw this stuff. There were people in my backyard at night. Why? People sending me threatening text messages, never investigated in the police department. People talking outside my house that I personally heard, talking about surveilling me. Surveilling. From distances of short range, medium range, and long range. There were people outside my house that I did not see, that my neighbors did, talking about the same thing. Who? Who would do that, and why? As for what I now have encumbered because of this, even after doing 30 years of law enforcement, and I now have a diagnosis of PTSD. That includes recurring nightmares, stress-induced stuttering and stammering, which I'm surprised right now I'm not doing, loss of sleep almost every night, loss of appetite. I weighed myself this morning, and 189 pounds the last time I weighed that amount was in college. The statement by the public that I've been subjected to out there, the looks, the stares, the whispers, that place I've lived most of my life. That changed my socialization skills from being an extrovert to an introvert, and restricted myself on my own accord prior to the tracking device and the so-called house arrest, of sequestering myself in a room in a house that no longer includes my life. What does this cost me? Everything. Everything I held near and dear. My marriage, and I don't blame my ex-wife. For a little bit I do, but I don't blame her because she had gone through a very violent domestic relationship with her ex, which included her being beat up consistently, suffering severe injuries that took her to the hospital. She was scared because this case changed me from the normal, happy-go-lucky person I was to being one who lived in constant fight over the lies set forth against Mr. Hilligus and myself. As for the future for me, I initially came to Reno in 1974 with my mom and dad because the economy in Vermont was bad. That's where I'm from. My cousins were here. They came from Vermont as well. But we had relatives, distant cousins who owned Heroes Club, the Smith brothers. And the shops were plentiful in 1974 in Reno. I guess they still are to this day as well. So my mom and dad came out here. My mom was a registered nurse. My dad was a former Washington County deputy sheriff. And also the state peace officer in the state of Nevada under the security department, where he served for 28 years. My mom was a nurse for 45. They both loved Reno. All the time they talked about loving Reno, living here. Both my parents were skiers. They went skiing all the time. They were very, very outgoing social people when it came to certain things. They stated they never wanted to leave Reno. They wanted to spend the rest of their lives here, and they wanted me to do so as well. That is not going to take place. I'll be blunt. I hate this town. I hate this town for what it's become. And that's a substantial statement from living here for 49 years. That's my opinion. I'm entitled to it. I intend to leave if granted probation in another state. Right now it's looking like North Carolina, and not because my ex-wife is there, because a very dear friend of mine who I consider family, the former sheriff of Mendocino County, California, Tom Allman, has offered me his house to live with him in Sila, North Carolina. As for the victim, the true victim in this entire situation, Susan Hilligus. I talked to her that day. She was so happy to see her son. She wanted to leave there. As Mr. Stege wants to say, it's not an Auschwitz. Oh, yes, it is. It's been consistently rated D by the state regulatory agency, that facility specific. In fact, the day we went in there to have Mrs. Hilligus leave there, a lady came and grabbed my arm and says, please help me. Please get me out of here. And I was like, ma'am, I can't. She goes, I'm not asking you to take me out of here. I know where my house is. Just open that door and let me get out. She was like, I can't stay here anymore. She said, they're hurting me. They're hurting me. And based on the evidence I've seen against with Mrs. Hilligus involved, with her black eye and her disheveled clothing and disheveled hair, I agree with you. There was a similar situation that took place in Las Vegas that bears mentioning. It was called the Rebecca Schultz case. And the only thing different was that Mrs. Schultz's father lived in his own home versus Mrs. Hilligus living in a assisted care facility. The daughter versus the son. A civil court matter and a civil court matter. The daughter took the father from her own house, which was being regulated by a guardian, and took him to Southern California, where Roger took his mother to Southern California. The court system demanded to return Mrs. Rebecca Schultz to return her father. She said no. The court did not do any criminal actions against him or her. They filed a contempt charge in civil court, and Mr. Guadalupe Olvera had to live the rest of his days with his daughter in Southern California without any criminal ramifications. The exact opposite of Mr. Hilligus. I believe Las Vegas and Reno are contained in the same state, just my recollection. The worst case scenario of guardian probate fraud occurs from the state, the Seattle Parks case, where she served over 40 years in prison for guardian probate fraud, where she actually kept people's remains in a storage unit after pilfering their estates and trusts. I did not know about all this stuff on the 8th of August 2019. I was just there to bear witness with Mr. Hilligus and Mr. Griffith. This case is not about violations of law, it's all about money. It's always dead about money. It always will be about money. And I will conclude with this. What would any son or daughter do to save a parent from being placed in an assisted care facility, such as Stone Valley, and bearing witness to allegations of abuse and also seen allegations of abuse and neglect? I cared for my own mother in her own home during the last years, months, days, hours of her life. I held her hand as she passed away. That's what she wanted. That's what I believe Susan Hilligus wanted. But she didn't get that. What she got was an early death sentence. And that's all I have to say.
Thank you, Mr. Handte. Mr. Stege.
Again, the court mentioned that jail's conditions on the table by terms of the agreement. That is not true. I fully intend to ask for jail as a condition of probation for Mr. Handte in the amount of 300 days. And the reasons are multiple. I start with this. Writing recently, the United States District Judge for the District of Columbia, Judge Lambert, remarked on the loss of truth in today's society, and he was tasked with the resentencing of a defendant. But what is of importance here is in the federal system, and I would argue that the state system also has as a feature a factor to be considered in imposing sentence. In the federal system, nature and circumstances of the offense, history and characteristics of the defendant, and the need for the sentence to reflect the seriousness of the offense, and importantly, to promote respect for the law and to provide a just punishment for the offense. And first speaking to Mr. Silverberg's comments about his surprise at the way that this case was charged, sort of this idea, if you don't have the facts, argue the law. If you don't have the law, then you just hammer the other guy to sort of impugn this prosecution for charging what the defendants admitted there was evidence to prove them beyond a reasonable doubt of. So I would ask the court to sort of reject that rather easily, right? This idea that, they shouldn't have charged my client, but Mr. Hilligus was more than willing to, and Mr. Handte both willing to plead no contest, meaning not that the state didn't need to rely on their admissions of guilt, but the evidence itself showed beyond a reasonable doubt they were guilty of burglary. There was overwhelming deception in this case. So I'll turn a little to the comments of Mr. Handte and his invitation to speak about facts, and we should always be about truth. And this, as a prosecutor, I'm privileged to speak the truth. Reading from the testimony of Oliver Miller, which is saying that he told, this is at page 16 of the preliminary hearing transcript, I informed Handte that I was concerned about what he wanted to do, that he wanted to effect a citizen's arrest on some of the staff members there. I told Handte what I told Hilligus, that we, as law enforcement, would not enforce could not remove an elderly person from the care or custody of the facility, and that it was a civil matter, and that he would have to hire an attorney to help him work through that civil process. That sworn testimony had in the Justice Court of Commander Oliver Miller. And that is what the thrust of that testimony was I knew Stewart Handte. Stu wanted our help to go get this person out of a nursing home, and we told him, we don't do that. Go to court. Stu, you want to get back into law enforcement? Do not do this. And speaking of the character of, I think that speaks to the defendant's character, Mr. Handte. We live in a free society where we value the equality of all citizens. Now, Mr. Handte, as he argued today, argued then to Oliver Miller, I'm special. I'm a former law enforcement officer. I should get special treatment. That is troubling to the state, that Mr. Handte views the fact that he was a law enforcement officer, that should give him special privileges under the law. Now, in this courtroom and as a prosecutor, we work a lot with law enforcement officers, and that is anathema to what it means to be a peace officer, to swear to uphold the law, right, which values equality for the law. And so the idea, from the state's perspective, that Mr. Handte would abuse his status as a former law enforcement officer is deserving of punishment from this court. The truth of the matter is, now he says today they were D-rated. As a matter of fact, they were A-rated. He says today, oh, Mrs. Hilligus was fine. He says today, oh, there's this other person who wanted out of there. He doubles down, triples down that this is an Auschwitz. He compared the audacity and the lack of sort of personal insight to compare this to Nazis is incredible. Now, of those things, he never mentioned any of that stuff in his interview, right? He did admit that he could tell that the supposed legal documents that he was going in there with were bogus. He said that he saw red flags with relation to these documents. The court noted, well, he's testified in court before, right? Like, that's, he knew what he was doing. That is absolute proof that Mr. Handte knew that what he was doing was wrong, and he did it anyway. And I'll sort of key in on his closing remarks that, his inability to sort of, and it is difficult to have a parent die, right? It is incredibly challenging, but that as a motivation to, when you have a commander of Reno PD saying, do not do this, Stewart Handte, and then to go do it anyway, that is troublesome, especially someone who had employment as a law enforcement officer. We often, and appropriately, as I do here, argue that people who have had that position, who have been given those powers to enforce the law, because law enforcement officers are given broad discretion and have a lot of power, that when they violate, because they do that every day, they ought to be punished more severely than others, and that is entirely appropriate. It is suggested today by both Mr. Silverberg and Mr. Handte himself, I think the word was exemplary, was used to describe his service as a law enforcement officer. The record bears some examination of that. He was let go from Nevada Highway Patrol for a number of reasons. Mr. Handte, in fact, himself addressed it during his remarks about a deposition, in which he admitted that he could just kill him, referring to the chief then when he was told to leave the facility. A whole series, now in this deposition, Mr. Handte, he believed he was wrongfully terminated or wrongfully removed from NHP. That, of course, is shown in the record that there was directed summary judgment against Mr. Handte. Among the things, a lot of issues with his performance there as a trooper.
I'm just going to check at this point. Any of this is actually in the court record. I don't think there's been anything provided.
Well, I gave leeway to the defense to say things that he related that he's aware of or happened. So I'm going to give the state the same, but I'll remind the state that, I've heard concerns like this before. Obviously, this is a different hearing, and the state wants to remind the court what it believes is important information from which to make an informed decision.
Right.
But you're starting to, so I wouldn't use the phrase pile on, but it's a little bit redundant. I understand the state has a different view of the Mr. Hante's professional performance at the end of his different roles that he served in this community.
Yes.
Noted, you don't have to hit the court over the head with it.
And to the extent that his sort of career as a civil servant should be mitigating, I suggest two things.
You say temper that with?
Temper that with, there's a probably 200-page police report written about him in relation to his time as the Mineral County sheriff, in which he engaged in sexual intercourse with someone who was actively.
Okay, let's do this. Okay, hold on. Let me suggest this to the state.
Because she was in drug court.
Okay, please stop. Let me suggest this. Each side is allowed by law to make argument to the court relevant to what we're here to do and to assist the court in making a fair and just decision. I'm telling you, Mr. Stege, that this type of information does not assist the court.
Okay.
So I would ask you to please move on.
Yeah. I heard the court saying the court will appropriately temper his claim of exemplary public service with that information plus the other that has been provided.
The court is aware of the issues that have been raised in prior hearings that the state has brought to the court's attention. I've also heard the response from the defendant to that, but I'll analyze that consistent with my analysis of how to fashion a fair and just sentence.
And so the question of sort of taking responsibility or I guess remorse, I think the court should weigh as follows. The defendant, it's compelling to the state that after the period after a plea and before sentencing is often a measure for the court to determine, is this a person who will do good on probation. The court also typically takes sort of signals from pretrial supervision as, is this a person who, if I tell them to abide by conditions, they will. And I submit both of those areas. The pretrial supervision aspect of Mr. Handte has been troubled. He has, I'll start with the flight situation where he was pulled over near Elko, and he made the statement that he was going to the East Coast. I'll add the multiple violations for engaging in media contact, media interviews. Some of those same media people have submitted letters in his support, but those against the pretrial orders of this court. And most importantly, from the time of the plea until now, pretrial supervision has filed at least 2, maybe 3 requests that the court addressed his violations. So this question of the defendant.
Well, they were concerned with his conduct,
yes,
but as well his attitude. And so,
yes.
but as I indicated when I took the bench, the court exercises discretion because of the upcoming sentencing hearing, and also they weren't of the type that gave the court so much concern that I need to have a hearing and consider changing his custody status.
Right, and
but it's not a good look.
It's a terrible look, and asking to sort of take a few steps back from this. Across this case, Mr. Handte has enjoyed continued pretrial supervision that most defendants would not. I mean, the number of violations is high, and those conditions that the court imposed were warranted. The court has found a number of times that those were warranted conditions, and the defendant thumbs his nose at them. And so in order to sort of preserve respect for the law, let's not forget the defendant, when he's sending emails still to this court claiming to be a victim of a corrupt legal system by RPD, the Sheriff's Office, the DA's Office, the Justice Court, the 2nd Judicial District Court, the FBI, the United States Marshal, Department of Public Safety, and Los Angeles County Sheriff's Office. That is lacking in sort of the fundamental understanding of the authority of this court. And that's not in the same way that Mr. Hilligus was premeditated in his violation that he stands here convicted of, or will shortly be. Mr. Handte similarly, right, knowing that these documents were not legitimate, going in and taking Mrs. Hilligus without authority of law, someone who literally had been charged with upholding our law, a person who swore to uphold the laws. And so, I'll sort of that respect for the law, but also sort of couple that with, you know, a dangerousness aspect, which is the court has been quite forgiving of Mr. Handte's use of violent rhetoric, saying things like participants in this case should be hanged, comparing people to Nazis, again, sort of that fundamental lack of self-reflection. Continued use of this violent rhetoric is troubling for the state and ought to be met with an appropriate sentence, which we've mentioned a bit about Mr. Hilligus's custody, right? Like, and self-inflicted for the most part there. But this idea of like for like, right? So like, now if anything, Mr. Hilligus's motives are kind of, it's more understandable, right? Whereas Mr. Handte's is more troubling to the state. It's more troubling that he believes, in the same way that, for example, in July of 2021, when he went to the county commission, he leads with, here's my retired police ID, you should believe me, I should get what I want. This idea of that fundamental breach of trust that he once held is more problematic for the state. This idea that they were in it together, they should be punished. Similarly, Mr. Handte ought to go to jail today, and the condition of his probation should be 300 days jail, flat time. The underlying suspended sentence should be 4 to 10 years. The conditions related to contact ought to be the same as with respect to Mr. Hilligus, and the division ought to have the authority to impose both house arrest and GPS as necessary, and extradition costs should be ordered.
Thank you. Court will be in recess for 15 minutes. Come back and make a decision.
All rise.
Thank you, Deputy. Please be seated, everyone. Okay, we are back on the record. Counsel are here, the defendants are here, the division is here. I'm going to start with Mr. Handte. So Mr. Silverberg, Mr. Handte, would you stand up? Let me get to the end, and then I'm going to work my way back. Mr. Handte, I am not incarcerating you today. I'm not. Over the recommendation of the state, the court has determined not to have you serve additional time in the Washoe County Jail. Okay? I say that for your benefit, for the deputy's benefit, everyone's. I will not. Now, does that mean we don't have things to talk about? No, we do, and we're going to do it right now, but I'm not putting you in jail. Hopefully, you never have to see the inside of a jail or prison the entirety of the rest of your life. All right. There being no legal cause why the court should not proceed, and based on your nolo contendere plea, the court does adjudicate you guilty of the felony charge of burglary. We all recall the negotiations here, which the court will follow. That being, if you successfully complete probation, the terms of which I'll announce in a moment, and the underlying sentence I'll announce in a moment. If you successfully complete those, and you are honorably discharged, you can come back and withdraw the guilty adjudication. You can withdraw your no contest plea and be arraigned on and sentenced to a gross misdemeanor for time served. So really the effort that you put into your probationary period will be reflected, hopefully, when you honorably graduate in either this court, proudly, or a different judicial officer, if I'm not here, will allow you to withdraw your nolo contendere plea. All right, but here's the underlying terms. The court does sentence you 19 to 48 months, Nevada Department of Corrections. That's suspended for a fixed period of time of 3 years, pursuant to negotiations. You have 103 days credit for time served, but frankly, Mr. Handte, whether it's 103 or 1,003, who cares? Who cares? It only matters if you're being revoked and you have to serve it. But you have that just in case, but let's both hope that that never happens. Financial piece. I'm fining you $500. I'm waiving the attorney's fees for what the court considers to be very hard work on your behalf by the alternate public defender's office. I know money is tight, so I'm not going to pile on. There are some statutory fees that I do assess as well. $3 genetic marker fee, $25 administrative fee, $150 DNA fee. So the amount that I've in total assessed here, if I did the math correctly, $678. Now, you also owe extradition costs, $1,064.40. Special conditions of your probation. Number 1, you are to report to the State of Nevada Division of Parole and Probation in person tomorrow. What time should he be there, please, for his intake?
I have on his paperwork 8 a.m.
All right, 8 a.m. tomorrow morning, please report. Follow their directions, abide by the rules, general terms that apply to everyone. Don't pick up any new charges. No drugs or alcohol. The drugs control substances unless prescribed by a licensed medical professional. Make sure they know where you're living. Make sure they know your phone number. If you want to leave the estate and move to North Carolina or somewhere else, don't do it and then ask for forgiveness. Get permission first. You have to make application. The division needs to contact their colleagues in the state you want to move to and get permission from them that they agree to supervise you. The word that's often used or thrown around is the compact, which I've always understood to be, countries have treaties between each other, states have compacts, which are agreements. So don't leave until and unless you have been accepted for supervision on the state you want to move to. No contact with Ms. Renwick or her family directly. Call her, don't email, text, go see her, or have someone do it for you indirectly, right? So do it with your approval or tacit approval.
Your Honor, could we just clarify family? Because of course Mr. Hilligus is family. Do you mean Ms. Renwick and her children?
Ms. Renwick, her children, I don't know if she's currently married. If she is, her spouse, and really that's what I'm talking about.
Thank you, Your Honor.
All right. Also, but no contact with anyone involved in this case. Any witness that's been identified. I'm not talking about Mr. Hilligus, but any witness that's been identified, any legal representative, judicial officer. No contact with those people. I give to whatever parole and probation office or officer is supervising you the discretion if you have a minor slip up, minor, not enough to bring it back to the court's attention and seek revocation or other punishment, but minor, they have authority to impose up to 90 days house arrest and a GPS monitor. I know how much you dislike the GPS monitor, so please follow the rules so that they don't exercise their discretion to seek to do that. Also, I know these are words you're waiting to hear. You can remove today. the or have removed today lawfully the GPS monitor that you've been wearing. Finally, Mr. Handte, and this is, I recognize this is going to be maybe difficult to monitor or enforce, but this is another term of your probation. You are not to create any inflammatory posts on social media or otherwise, or rhetoric that to a reasonable person would attempt to incite or inspire violence. Can you state your view of the system? Yes. Can you comment on improvements you want to see? Yes. Can you talk about your personal journey if you care to? Yes. Can you do things that to a reasonable person would suggest that you are asking them to harm, start violence, things like that? You cannot. If you do that, it comes to the court's attention, we're going to have issues. So I'm strongly encouraging you, and I'm ordering you to not do that. All right, I'll leave it right there. So one more time. I've assessed you the money it costs to get you back to Nevada. I've assessed you the fines and fees. I've told you what your term of your incarceration is. Excuse me, the suspended sentence of incarceration, but you're never going to serve that. You have 103 days, as I've mentioned. Your probation is 3 years fixed. You're to report tomorrow at 8 o'clock. Division has house arrest capability. Ms. Berryman, did the court overlook anything that you would like identified as a term or condition of probation?
I assume that your general search and seizure, as you put the...
Well, let's stop there. Let's make sure we're clear. You know, generally, without a warrant, you can't enter somebody's home and search for something, in your case, evidence that you're not in compliance with your probationary term. But often, the court identifies as a condition of probation that the division, whether Nevada or whatever state you're living in, if they accept you, has the right, without a warrant, to come to your home, knock on the door, 2 in the morning, you're in a t-shirt and boxers, you gotta let them in, and they can look around. They don't have to have a warrant. That's often a condition of probation. That would include often computer, cell phone, things like that. I don't know that, based on recent Nevada decisions, that this is a computer or cell phone issue. On the other hand, I've just told you I'm not allowing you to make posts that would incite a reasonable person to violence or harm. I don't know, how strong does the division feel about that?
I believe we feel very strongly about the digital search and seizure.
Okay, and then I'll let Mr. Silverberg be heard. Mr. Stege, any thoughts on that, please?
Given that important condition that I've sort of touched on, I support the division.
Okay, Mr. Silverberg.
Well, Your Honor, I have a little bit different view. If there is reason to believe that there have been those sort of posts, then I would not object to that.
As opposed to a knock on the door after 9 months of good behavior, no issues, nothing like that?
Yes, sir.
All right, I'll say that. So to the division, the court, as a condition of probation, gives to them the authority, without a warrant, if they have some type of reasonable suspicion that improper activity is ongoing, to enter Mr. Hante's place of residence, his vehicle, or any electronic device that he has custody or control over, to search for evidence that he's in violation of the court's order.
Thank you, Your Honor.
I think the court sort of fused together two things, that they need cause for residence searches. I don't think that is required by law, and I think that is problematic.
I think the electronic device.
For electronic, I disagree, but I understand the court's ruling.
That's what I meant to say. So one more time, home is different than electronic devices. I believe our Nevada Supreme Court has recently spoken to that.
Thank you, Your Honor.
Okay, but Mr. Handte, the message here is temper your comments appropriately. Don't give the division any reason to come to your home and search your computer or your cell phone. Please do exactly the opposite and measure the words or the way you use your voice, which at this point apparently carries farther and reaches more people than other citizens. So you use it for good purposes. All right.
Thank you, Your Honor.
Anything else from the defense?
No, sir.
Ms. Berryman, you have some paperwork you want to give to Mr. Handte?
I do. Mr. Handte, this is the address. Please bring a picture ID with you.
All right, so take a look at that. Mr. Handte, you may have a seat. And Mr. Silverberg, you may have a seat. Mr. Goodnight, if you please rise, and Mr. Hilligus, you may remain seated. All right, so I've already mentioned that this court recently presided over the mental health program for 18 months and is a very strong advocate for not only specialty courts in general, but the mental health court program in particular. Does a lot of good for a lot of people. Indeed, yesterday, the court was up at University of Nevada, Reno, talking to a class of behavioral health students about careers in this growing and understaffed field, and also the specialty court programs available here at Second Judicial. So I'm an advocate. I'm a supporter. I believe in them. In addition, it's clear that there are two Mr. Roger Hillygus. There's the one before 2010, hardworking, good spouse, law-abiding, spent his time on earth in a productive way that helped make the community that he lived in and worked in better. Fighting fires or helping people learn and instructing them. Driving children to and from school. Teaching apparently English in Southeast Asia. All kind of cool stuff. And then he got hurt. And then his worldview, his approach, his thinking changed. It caused a series of civil disputes leading to this criminal justice charge. The court has discretion in granting Mr. Hilligus his ask for diversion. And for all of us in the courtroom, let's remember what that means. It means an opportunity to work on yourself, stay out of trouble, get stronger, never be adjudicated a felon, and when you successfully complete it, and other supervision requirements, case is dismissed. The alternative, be adjudicated a felon. Pursuant to negotiations, no jail or prison time, comply with probation, never go to jail again, never go to prison, and if a certain amount of time passes after probation ends, seek to seal the record. So that it happened, but you can legally answer questions to the effect that you have not been so convicted. With all due respect to the defense, the court declines to grant the opportunity of diversion here for two independent but equally, in the court's estimation, viable reasons. The first being the substance, what happened. Too involved, too thought out, too ongoing, too many bridges crossed, too many acts of conduct that was extremely concerning. Understanding that taking Mr. Hilligus, at best case, his heart was in the right place, but unfortunately, that doesn't change the court's view. Too much happened here. This is not, in the court's estimation, taking everything into account, a diversion case. The second reason, independently, is logistics. This court, 7 years, thousands of matters, I do not recall ever having a diversion case with as many challenges logistically. Supervision challenges, location challenges, approach challenges. It's too much. The court would not be in a position to supervise to the level requested. Don't know what kind of therapy, treatment, counseling, medicine he would get in other places. Am not prepared to do remote check-ins, particularly when the person who's remote checking in had had to be brought back to the state of Nevada 2 separate times. It's too big of an ask. Do I commend the defense from recognizing, from approaching everything that happened here with a mindset toward let's work on ourselves to make sure nothing like this happens again and regain our balance? Of course. Of course. Anyone who knew this guy before 2010, they want the old Roger Hillygus back, or as close of a version to the old Roger Hillygus as can be gone back at this time. But is the court going to find that a diversionary grant is the way to do it? The court does not. That said, but for these 2 holds, I would say I want Mr. Hilligus checking in with the division tomorrow as well. But in a moment, you'll hear how there's going to be a slight version of that. So, no legal cause preventing it, based on the nolo contendere plea of Mr. Hilligus. As with Mr. Handte, the court does adjudicate him guilty of the felony charge of burglary. Now, his sentence, and he's placed on probation, as was Mr. Handte, for a fixed period of time of 3 years. And like Mr. Handte, he's not to leave the state of Nevada until his division officer here in Nevada gives him word that his request to move to a different state, sounds like Tennessee, has been approved, that they will supervise him there. So please don't leave, Mr. Hilligus, and then, we have to find you. Please stay here, follow the rules, get permission, and hopefully you find yourself in Tennessee in the not too distant future. Your underlying sentence, a little stiffer than the sentence pronounced for Mr. Handte, 24 to 60 months in Nevada Department of Corrections. But again, sincerely, I hope you never serve a day of it. You have 550 days credit for time served. The financial piece, you are fined $500. Attorney's fees are waived. $3 genetic marker fee, $25 administrative fee, $150 DNA fee, along with the court does impose the amount of money it costs to extradite you back from both California and Missouri, totaling $4,535.57. The terms of your probation, also no contact with the same folks identified for Mr. Handte.
So, Your Honor, in regards to that, what I heard the court say was no contact with anyone involved in this case. That's vague in my mind.
It's a bit vague. So anyone identified as a potential witness by the state, any one of the attorneys, any one of the court or court personnel, or any of the counsel.
By attorneys, you don't mean me or Mr. Hill?
Of course not. And your attorneys you can contact.
You're talking about the attorneys. What attorneys are we talking about?
The attorneys that are adverse to the side, to the parties involved.
Mr. Stege.
Mr. Stege. I don't recall if he had somebody else assisting him.
Anyone else? I'll defer to the state.
Well, there's been a lot of violent rhetoric. Mr. Hicks's name has been mentioned. Every JP who's ever touched this case has had their name mentioned.
Well, I mentioned judicial officers, so those, and then those identified by the district attorney's office as having been contacted or named.
I think it's fair to say they have no business with the district attorney's office going forward.
That's probably a good way to interpret that. Mr. Goodnight? There'd be no reason for either of the defendants here to contact directly anybody currently with or having worked on this case from the district attorney's office. The same conditions with respect to a search without a warrant applied to Mr. Hilligus. The same conditions with respect to house arrest and GPS monitoring apply to Mr. Hilligus, as did Mr. Handte. And then the difference being then with Mr. Hilligus, you are to report to the State of Nevada Division of parole and probation. Their office is just down the street here, 475 Valley Road, within 2 business days of being released from custody, whether you're released from the Washington County Jail directly, whether from Lyon County, whether from Story County, but within 2 business days. So if you're released on a Friday, you got to be there by Tuesday. If you're released on a Wednesday, you got to be there by Friday. You have to check in. But I never want you to be in jail. I never want you to go to prison. I want you to go follow whatever path you've laid out for yourself. Stay out of trouble. Stay in touch with your probation officer. I hope you find your way. Ms. Behrman.
Your Honor, did you want to put a time frame on when those outstanding warrants should be resolved?
When the outstanding?
He has no control over that.
Well, usually, go ahead.
He's in custody, there's holds on him that the procedure will take.
Well, the question is, do I say as a condition of probation that he resolve those 2 outstanding matters?
I think that's fine.
And so that is usually a condition, and so that will be the order of the court. But he has hold, so I don't believe.
I don't believe he'll be leaving unless they transport him on those holds, Your Honor, either. So I was going to suggest maybe 180 days, which is 6 months, which is a long
For
time,
him to,
resolve the warrants as part of his terms and conditions.
I'd object.
well, hopefully when he's being released, it's been resolved, right?
No.
But we need, what she's saying is we really need a date certain from which he needs to have taken care of this. Let's say 240 days, okay? But really, it should be, according to the defense, these matters should be resolved rather quickly.
Right, I'm just not sure why we have to put a deadline on that.
Well, we usually do.
Yeah, I think it's really that he submitted himself to the authority of those courts. Right now, he's in warrant affairs. For the ultimate resolution of those, we can't predict how long that will take, but I think it's wise to order that he sort of submit himself to them within 90 days in case this procedure doesn't work, the holds or what have you, if you were to post bail on those and then never show up, so.
Well, we're trying to get to the same place here,
Yes,
where he gets these things done so he can go to Tennessee or wherever other state he wants to go to. But I think what I'll do is I'll leave it at 240 days to have these resolved. The division can extend that at its discretion if it finds that there's good cause for reasons out of his control that are preventing him. I would anticipate there wouldn't be a probation violation filed.
Right, Your Honor.
That's the way I'd leave it there.
Right,
So-
about the time we're up against that 240 days and those are still open, we can come back to the court.
Or you can lobby the division not to file a violation report. That's another approach to it, okay? All right, so with that, that will conclude this hearing. Now, you know, Mr. Hilligus and Mr. Handte, they can believe what I'm about to say or they cannot. But I sincerely hope that they move past this to the best of their ability and they go on to live a life that doesn't involve interaction with the criminal justice system that brought them here, and they both find their own way to happiness. That's the order of the court. We're in recess.
Thank you, Your Honor.
Thank you.